Welcome to The Point of View. This is your favorite current affairs show here on Channel 1 Television. Here on The Point of View, we pick the right topics, get the right guests, and ask them relevant questions on issues that matter to you. We're live tonight. Two big stories. Bernard Entry Boisiako, a.k.a. Chama Wontumi, after 1 week of a tango with security agencies, has been released. It was released moments ago from the offices of the Yoko. Bring you the latest on that. And whilst Wontumi is released, Ofori-Atta is declared wanted again. Former finance minister has had cause not to return to Ghana for medical reasons. The OSP is having none of that and says Ofori-Atta must come down at all costs. Tonight we delve into the issue with two legal brains. Where are we with the two cases? Stay with us.
In a wide position, so what's next?
Ronaldo. Could be. There's still danger here.
Goal! In 1924, my grandpa was a champion. 2024, Meso is a champion.
Hey, digital champion. It's about the end.
Digital champion, who can't TV shop online?
Let me help you get what you need from Enterprise now.
It's this simple. I just log into my Enterprise account using the Enterprise Self-Service Portal. Then, I just click on this button for their new Advantage Point Loyalty Scheme. Then, boom, the fun begins. Wow. Yes, once I start making purchases under any subsidiary, I can now earn a lot of points and redeem it as airtime, Momo, and more.
Hey, customers only.
Even on your birthday.
You earn points.
Yes. Even when you like and share on the portal.
You earn points.
Yes.
Purchase an Enterprise policy today to enjoy this exclusive offer and start earning rewards. Because nothing you do should be pointless.
Oh, then redeem more of your points and send to me.
Hey, Mr. Digital Champion.
Enterprise, your advantage.
Do you want a healthy smile?
Persistent bad breath could indicate gum disease. I'm Tanya from Bethel Dental Clinic, Ghana. Did you know that gum disease is a common cause of bad breath or halitosis? But there is hope. As dental hygienists, one of the main things we do when you come for your periodic visits is to examine your gum health by completing a periodontal assessment. Gingivitis, the early stage of gum disease, is common and characterized by swollen, bleeding gums and halitosis. The good news is that gingivitis can be reversed back to healthy gum tissue. Regardless of which stage is present, a professional cleaning or deeper cleanings are needed as a first step to treating halitosis or bad breath. So, schedule your appointment with your hygienist now to learn more about maintaining healthy gums and getting rid of bad breath.
Healthy smile.
Welcome back. So tonight we're bringing you updates on two significant matters. Chairman Wontumi has been released probably less than an hour ago. Our Charles Kumi was there during the previous bulletin, brought us some highlights, and we just spoke to his lawyer, Frema Edunyami, speaking to one of his lawyers, who officially explained what he was cautioned of. But we'll take you back a bit into why he was detained and the sequence of events. I'll be speaking to two, I'll call them legal political minds. So Hassan Tampuli is MP for Gusau, and he is also a lawyer. He's in the studio tonight. Hassan, welcome. Good evening.
Thank you very much, Bernard.
You've been working overtime in opposition. You've been working overtime. This weekend you were all over. Today you are here. Thank you so much for joining us.
Always a pleasure to be with you.
We are also privileged to be joined by the former MP for Tamale Central in the person of Inu Safuseni. He'll join us shortly. He's joining us virtually to also express his views on these two very significant matters. Were you part of the MPs who marched to Yoko last week to demand Wontumi's release?
Thank you. Good evening, and good evening to your viewers. And in particular, good evening to the good and virtuous people of Gushegu, my constituents. So I wasn't in town that day.
Okay.
I was in the north for the funeral of the late Paramount Chief of Miang, the Miang Lana Abdullahi the Fourth. So that's where I was when that event took place. So I'm being told that it was done against the provisions of the Public Order Act and so on and so forth. As a matter of fact, I'm not too sure what that meant because they could have driven to the offices of Yoko individually or even in a convoy. And then when they get to the place, they get off their cars. Would that be considered as a violation? So they chose to walk instead of driving in their cars.
Okay.
So there was no violation of the Public Order Act per se. But the reason for that move was that if you look at the antecedents of that whole incident, first on Friday 23rd, security agencies stormed the residence of Chairman Wontumi in Kumasi and then insisted on gaining access. Of course, that didn't happen. And Chairman Wontumi's lawyers sent word that he will be visiting the CID, who were the ones who wanted him on that particular occasions. And then on 26th, Chairman Wontumi honored their invitation at the CID headquarters, went and then was given a police inquiry bill and requested to return the next day, 27th. He did same, right? He went to the CID, honored their invitation, cooperated with them, went under interrogation, and again was discharged to leave, granted police inquiry bill. It was just when he was stepping out that he was arrested in that Rambo style, which has come to be the best description of what really took place that day.
On Sunday who did not agree to that description. I remember the host pressing him because he was with Wontumi in a car, and he said an official of Yoko stopped them, and basically he got down from his car and joined an Yoko vehicle, and the Yoko official joined Wontumi in his car. So he did not describe it as Rambo, but maybe that's your
that's the description there, yeah, of course.
Fair enough.
So as it is, this is the person who is already cooperating with one of the security agencies. So the needless show of force was what became the immediate trigger of the minorities, furore and indignation. So it was more or less like, so what is it about this gentleman that you invited him by one security agency, and then another security agency also goes to pick him up. What if maybe the day that Yoko releases him, at the time, that was the thinking, the day that the Yoko decides to also release him, is the NIB coming to pick him up, and then next OSP will pick him up? We thought that was abuse of state power, and then it sent a certain signal of some amount of political vendetta against a political party opponent, more especially the chairman of one of the political parties, the biggest political party in the opposition. So we thought that was wrong, and we needed to send a certain statement. So that was the reason. And then when they got there, of course, they didn't get access. At some point, they didn't even have seats to sit on. So people said, well, why were they sitting on the floor? But there were no chairs. How long can you be standing? You understand?
But is Yoko a place for the number of MPs who went there? Is it as a large place that can have a seat for uninvited MPs who come there without prior notice?
I don't know whether you've been to Yoko before, but they have facility, they have offices, conference room that can contain almost all the MPs that went there that day. So I don't think that, they were doing anything wrong. Of course, look, in a democracy such as ours, it's a growing democracy. Of course, it's one of the most enduring since, the First Republic. We need to do things differently. We cannot say that, somebody was arrested like that before, so we should continue that way. Then we are not growing.
I see.
Then where is the reset? If we have said that we are going to reset, then it calls for new ways of doing things, ways that would accord with the letter and spirit of the Constitution.
Does it matter what he's been charged with in the minorities' decision to protest in Parliament and walk? Did they avert their minds to the specific alleged offences?
Now, at the time that the minority walked to the offices of Yoko, nobody even knew exactly what the charges were.
Okay.
we knew what the charges were at the CID.
Okay.
Had to do with, mining without license, mining within a concession, a forest reserve, and so on and so forth. So those were the issues. So we were all at sea as far as the UOCO charges were concerned. But later on, we found out that it had to do with tax evasion, fraud, money laundering, and so on and so forth. There were 6 charges. For the specifics, one is not to, but it is becoming clear that one of the issues that the UOCO is using against Chairman Wontumi is about an exim facility. That's what is being speculated right now.
Yeah.
Now, if you go for a facility from an agency like Exim Bank, what are the remedies available to the bank in the event that, for the want of a better word, you default? Isn't it to take a legal action against the person? So this is entirely a civil matter. As far as my assessment, goes. It's entirely a civil matter. And from what we are being told, the matter is even already in court. Exim Bank has already taken Chairman Wontumi to court, and the matter has been, fought in court. So I don't know which aspect of this matter that UOCO is handling. So we'll be waiting for further and better particulars, from UOCO to get a very clear understanding as to exactly what the specific charges are. Then his lawyers will be able to have their client have his day in court.
All right, let's take the initial comments of Alhaji Inusa Hussaini, who is a former MP for Tamale Central, a lawyer himself, a former minister for many portfolios. You yourself were a former deputy minister for transport.
That's right.
Alhaji was a former minister for lands, which was a more prominent role among others. Alhaji, thanks for
Minister
joining
for
us.
Roads and Highways.
He's been minister for many important portfolios. Good evening, good evening, sir. Thanks for joining us.
Bernard, thank you for having me.
It looks like life out of government is calling you about roads to be fixed. Nobody's disturbing you about the Fufusu Solar Road. So you are very happy.
Now we fixed the Fufusu Solar Road before we left office.
I know, but it's in a state of disrepair now. I think it needs a lot of work.
That was 8 years ago, or more than 8 years ago. Yes.
Yeah. And of course, Galamsey is still an issue. So the sectors that you used to manage still with many, many issues. But let me not even push you there too much. I'm sure you've been following these 2 issues. The Wontumi matter. Today will be a week since his visit to the CID, and he's been held for a week, essentially. The minority believe that state power is being excessively used to target a political opponent. What are your thoughts on that?
Well, you see, when you are dealing with the investigation of alleged criminal activities of citizens of this country, the only thing that we can ensure or talk about is whether such activities fall within the confines of the law. Because the protective safeguards, or there are protective safeguards for citizens who are subject matters of interest and who are being investigated for various acts or commissions that they did while, if they are public officers, while in public offices, or if they are private individuals while carrying out their private activities. Now, and the most important constitutional safeguard is especially for people who have been arrested, detained, or restricted, is to be submitted or presented before the courts within 48 hours, or make arrangements for them to be released temporarily on bail, or to release them all together if the investigative authorities have no reasons to continue to detain, restrict, or arrest those people. So that's a very important constitutional safeguard. In the case of Wontumi, yes, he was arrested after leaving the CID office. The IOCO were quite aware that they could only hold him for at most 48 hours. And if after the 48 hours they still required him in police or Yoko custody, they had to go to court. But if they didn't want to go to court, what they could do was to give him bail so that he will be attending upon Yoko anytime he was required to do so. My understanding of what happened was that a bail was issued to him. I mean, he was granted bail in the sum of 50 million Ghana cedis and 2 sureties to be justified. His inability to meet the bail terms does not in any way suggest that his rights had been violated. No. The Yoko had granted him bail. If on the day he was granted bail, he was able to execute the bail, meet the terms and conditions under which he was granted bail, he would have walked away from Yoko, but only attend upon Yoko anytime he was needed to do so. So it is my humble view that having granted him bail within the 48 hours allowed by the Constitution, a very important constitutional safeguard for his rights and liberties as an individual of this country, Yoko cannot be said to have been in breach of any law.
Wonderful. We are told, however, that at least some members of his team claim that he had secured or met the bail conditions as of Friday. But we were told that there was a dependency of a case filed on his behalf against Yoko, which was to have been heard tomorrow, Tuesday, which sort of delayed his release. And therefore, we're told that today they had to withdraw that case to allow for his release. Do you understand that whole confusion? Because for us non-lawyers, we don't really get it. He's sort of met the bail condition, yet there's a pendency of a case, so he will still be held. Is that the facts as you've been told, and does that make sense to you?
Well, so on Friday, I mean, obviously, no one, and I've heard people say that they were going around looking for 50 million. No one was asking Bernard Bosiaku to provide 50 million Ghana cedis as bail bond. No, it was 50 million. That's the condition of the bail. And the 2 sureties must be justified. That means they must have landed properties.
Okay.
That is in their name, which they can use to secure or as a security for the release of the accused person. Now, when the court or an administrative body grants bills with terms like sureties to be justified, which sureties or security has to be provided for with landed property, the investigative body will have to go to inspect the properties, inspect where the sureties live, go to the land title registry to verify the authenticity of the landed documents that have been provided to secure the release of the accused person. Now, when all that is going on and a fresh action, mind you, the bail terms are the administrative action of Yoko.
Okay.
Now, so that administrative action is subject to judicial review.
Okay.
Now, if somebody is of the view that, or if the lawyers of Chairman Wontumi are of the view or were of the view that the bail terms were harsh and onerous and only intended to continue to keep him because they knew at the time that they were granting the bail that the Bernard Bosiaku would find it difficult to meet the terms and conditions of the bill, and they were so made to circumvent the law and keep him in detention. You can go to court to argue that the terms of the bill were in effect an attempt to deny him bail because there was no way he could meet it. And they and invite the court to review the terms and conditions of the bail.
Okay.
Now, the confusion here is that it appears to me that, and that is what I gathered from Andy Appiah Kobe's statements, that he and his client knew nothing about the fresh application in court seeking a judicial review of the terms and conditions of the bail.
Yeah.
Now, the Yoko too had their hands tied because even though they were dealing with a lawyer on record, there was another person who was in court seeking to review the administrative decision of Yoko.
Okay.
Now that review could go one way or the other. That review could result in the reduction in the terms and conditions of the bail or an increase in the terms and conditions of the bail. And so, and that decision itself, I mean, nobody knows. I don't have the court documents. You need to understand that if the application was made ex parte, the court might say that, well, because of the gravity of the offense and the matters that have been deposed in the affidavit in support of the application for a review of the terms and conditions of the bail, that application be made on notice. Now, if the matter was on notice, then it requires some number of days for the UPO to file a response. So that itself, coming late in the day, and particularly on Friday, would have operated to extend the time Bernard Busiako would be in custody, in the custody of Yoko. So that is why I think that it was a smart decision to withdraw the application today to be able to facilitate the release of Bernard Busiako.
So Hassan Tampuli here, I think on Saturday, said that particular suit was on the instruction of Mr. Wontumi's spouse, correct?
That is correct.
So, which means that there were different legal things happening around him. Is that normal?
Well, as you just rightly read, at some point when it became, increasingly clear that we had gone beyond the 48 hours, that was on Thursday, there was some amount of, agitation, in the camp of Chairman Wontumi, especially his family, his wife in particular. And so she obviously didn't even have access to him, all right? And so Andy had prepared, a similar application.
Okay.
The same thing Gary filed, Andy had also prepared one. And Andy's plan was that, from what he has said publicly, that he was waiting as at 3 o'clock on Friday. If he doesn't get any indication that Chairman Wontumi will be released, then he will go and file. So between the two of them, one would have filed anyway.
All right.
And probably, Gary took the lead to file at 2:35. So if you look on the application, you'll find that it was filed at 2:35 at the Judicial Service. But just let me respond quickly to what my senior brother, Yunusa, just said about his reference to Article 14.3. My understanding of Article 14.3 is a bit different from his. Article 14.3 says that a person who is arrested, restricted, and detained upon reasonable suspicion of his having committed or being about to commit a criminal offense under the laws of Ghana, and who is not released, shall be brought before a court within 48 hours after the arrest, restriction, or detention. So the responsibility was on Yoko to have taken Chairman Wontumi to court when the 48-hour period was about to lapse. He didn't need to file any application for variation and so on and so forth. It was now left for the lawyers of Chairman Wontumi to decide whether to go for just the review of the bail conditions, or to file a habeas corpus application in court for Chairman Wontumi to be produced in court in accordance with Article 14.3b. So willy-nilly, Yoko should have gone to court. So his continued detention, as far as I'm concerned, was a violation, and I keep saying a egregious contamination of the Constitution.
Okay.
So you must bring him within 48 hours.
Okay.
Whether, he meets the bail conditions or he doesn't meet the bail conditions. And this is very, very clear.
All right. Let me add something. You said you felt that having gone to CID, then being detained by Yoko, it looked like there were other agencies that were going to arrest him. Indeed, the majority chief whip on Saturday also said that the Financial Intelligence Center has built a new case against Wontumi. So that suggests that there was a third leg of the argument. Again, is that regular? So because it looks like the CID dealt with matters of mining, Yoko dealt with issues of loans and financial loss, and the financial intelligence, we are told, has to do with a more complex web of financial crimes. From your understanding of those bodies, how does that sit with you?
So you see, clearly there's an attempt to frustrate Chairman Wontumi. The CID, from the scope.
And listen, viewers, by the way, this is the release video. So that's the MPP General Secretary working with the former General Secretary and Chairman Wontumi, who's in a reddish attire upon their release. So Justin Kodia Frimpong and Chairman Wontumi coming out. So please continue.
So we're discussing the,
so you are saying that
issue about
FIC,
the multiple
multiplicity of
exactly,
and that's Brian Champon, by the way.
And I've made the point, especially on the floor of Parliament, that too many of these agencies are becoming too much, not only on the taxpayer but also obfuscate a lot of things that we do. CID, I believe all of these that we're talking about can competently prosecute a matter of
by the CID alone.
CID alone, I believe very strongly they can look for the relevant provisions under the Criminal Offences Act and other extant laws of the Republic to prosecute this case competently. Now, there are areas that Yoko has specialization in. Special prosecutor can equally tap a person for the same offense that Yoko can also get. Similarly, CID can also check, arrest a person for the same offense. So it's as if they are passing him to themselves. They are calling each other, Charlie, I've released a man, so it's your turn. They are going to be passing him like a football. So as soon as they release him, and then, what's the name? Now, we are not too sure whether by now OSP is hiding somewhere waiting to pick him up. Or maybe the NIB. So this is a violation of his constitutional rights. The person is considered innocent by our criminal jurisprudence and in the common law jurisdiction generally. A person is considered innocent until proven guilty or he himself, goes to make a confession. All right? Now, Chairman Wontumi is being treated like a criminal already.
Well, the Deputy Attorney General had said that Wontumi was being investigated for alleged criminal offenses, and then he listed them: fraud, causing financial loss to the state, and money laundering, which appear to be different kinds of offenses. So that
CID can prosecute for fraud. They've been prosecuting Ghanaians.
What about the money laundering charge?
Yes, they can prosecute. They can look for a provision in the Criminal Offences Act to charge him for money laundering. They can look. I'm saying that there are offenses that can be committed under other laws that the CID has the competence to charge. To take
so no need
control.
To bring Yoko and FIC in.
You don't need to bring all of these agencies in. Sometimes, if it is, especially in this case, where there are some other offenses which are already being investigated by the CID. So what are you going to do?
Well, he mentioned a wider international organized crime syndicate. That's the word the Deputy AG used, which suggests organized crime, which be in the ambit of Yoko.
So wait, Bernard. So today, Chairman Wontumi is being charged by the CID. He goes to court. The following day, Yoko is charging him for a different set of offenses in another court. And then OSP is charging him for
OSP
another
offense. FIC.
Or FIC is charging him for different. I mean, really, that is,
It should be consolidated.
It is abuse of the, the.
I'll take a break. When I come back, I'll ask lawyer Inusa whether he agrees.
It's completely needless.
We'll be back with this. This is the point of view tonight. We're digging into two issues. Chairman Wontumi released. We're just trying to understand the matters. When we come back, we'll also look at Ofori-Atta, now declared wanted by OSP. Stay with us.
Remember who we are seeing now. At risk of prostate enlargement. We a member or her. 20 ebitimi prostate cancer. 5 bitimi afamu. Nadia ubefamu.
Actually, this is not my fault.
And to wada. Entina many Executive Prostate Center.
Executive Prostate Center is a unique medical center where we harmonize in-depth traditional medicine with cutting-edge science and technology to cure, to treat, and to prevent diseases like prostate enlargement, prostate cancer.
Executive Prostate Center. Madame home. Facilities no any professional medical care.
Sisi a bibia clear system no. Ye nro ne so de natural. Into we koso afama ye.
Executive Prostate Center. My cured.
Where to get polytank?
Oh, and you're up fine.
Go straight.
Oh, I want for left, right.
That's right. Ghana na ye wono. So when you do more, and ye that now. Who knows? I beg, na here. Me pe polytank at all. And you think I'm in your bed to be able to never you. Oh, food to be here. Enjoy your kura.
Akuya bulambo customer. Emuha.
Like they took my eyes. Go to the distributor and you give the original polytank. Polytank. You hear the sound?
Polytank. Papananka Sankasa.
In a fast-growing urban environment like Accra, safety should not be too far-reaching. It should be as easy as ABC. Hear the real stories from those who now feel safe like never before with Response 1.
We were held at gunpoint in our own home, and they got away with it.
We didn't have Response 1 back then. That was the most terrifying experience of our lives.
But after that, we subscribed to Response 1 to ensure that never happens again. The last time the hoodlums tried, we had installed Response 1 monitored alarm system. Their response team arrived, followed by the police, to ensure we are safe.
Don't wait for tragedy to strike. Protect your home with Response 1's monitored alarm system and our theft protection guarantee. Immediate response, real protection. Response 1, stay connected, stay protected.
Welcome back. We are live tonight. We want to hear from you. What do you make of the release of Chairman Wontumi? We just showed you some footages of himself, Justin Kodia, Frimpong, and then, of course, John Buedu, and then you saw Brian Champon, who we are told was one of the sureties. There's a second discussion around MPP leaders falling over themselves to show loyalty to Wontumi. So everybody's been there. Bawumia has been there. We are told Kenneth Japan was there. Educhum was there. Brian also helped to secure. So it looks like everybody in MPP who matters wants to show their support for Chairman Wontumi. That will be a separate conversation. But Alhaji, let me take your final thought on the legal issue your colleague here raises. Why is CID, Yoko, and now FIC, we are told, interested in one man? It's almost like he says they are passing him on like football. It's a violation of his right. In your practice, is this normal for at least two institutions and a third? Because we were told by the majority whip that the FIC also has a dossier against Wontumi. Is that best practice?
So the first question is that which rights is being violated? So we need to understand which rights of Wontumi is being violated. The second thing is that these are institutions of state established with specific mandates. So there are jurisdictional issues to be overcome. So you have Iyoko dealing with economic and organized crime and money laundering issues. So that's the specific jurisdiction that has been given. And that because it's a specific jurisdiction, my brother in the studio knows that where there is a specific legislation dealing with a matter, general legislation will not suffice if you use that for the purposes of dealing with the matter. So yes, there must be there is a Criminal and Other Offences Act. But because there's a specific legislation dealing with specific crimes committed by people, which crimes ought to be investigated, those institutions with those specific jurisdictions are better suited to investigate them. So you cannot see Office of the Special Prosecutor going to investigate an offense involving let me use the money laundering, because they had said in the case of Cecilia Dapa that the matter, their review of all the facts touching and concerning Cecilia Dapa fell within the ambit of money laundering. Never mind that they never found the predicate offense. But and if it was money laundering, it was the view of the special prosecutor that the proper institution to deal with that was IOCO. So as a lawyer, I will always advise my clients to subject themselves to the various institutions. You see, I've heard our people argue that they would have been comfortable with all the investigative bodies, which is a little different from what Honorable Tampuli is saying. He thinks that the CID should have been given the exclusive mandate to deal with Wontumi. I've heard others argue that, well, they would have been comfortable if all these institutions were seated around a table and investigating, or if you want, interviewing or having a conference with Wontumi to determine whether or not crimes have been committed under their various jurisdictions. And now say, well, that will be fishing. That will be fishing. I mean, if all the institutions are gathered around a table and trying to look for offenses that have been committed under their various legislative arrangements or regimes, you will be exposing the accused person to undue harm. Undue harm. So, yes, it's unfortunate that Wontumi has brought himself within the ambit of many institutions. All right. The thing is that this is gratuitous. He for his own benefit, he needs to appear before all the institutions, and I'm sure Appear Kubi will well advise him not to allow all the institutions together to subject him to an investigation, which answers or questioning which answers can help fund criminal activities in other institutions.
Fair enough. Let's go to the next issue. Talking of appearance. Ken Ofori-Atta has to appear before OSP, according to the special prosecutor. Let me give you a quick timeline of events. January this year, so this started in the early hours of this government. The OSP officially notified Mr. Ofori-Atta that he was a suspect in 5 separate cases and asked him to appear in person on February 10. So this is January 2025 we're talking about now. January 31, Ken's lawyers informed the OSP that he was abroad indefinitely for medical reasons and offered to represent him in his absence. All right? A week after that, February 5, the OSP rejected the claim of indefinite absence and demanded a firm return date by February 10, warning of legal consequences for failure to comply. It also reminded that legal representatives cannot respond to criminal charges on behalf of clients. So the OSP was having none of that, this idea of indefinite absence for medical reasons. So this was February 5. 5 days later, Mr. Ofori-Atta's lawyers submitted a doctor's note stating that he was undergoing tests and possibly surgery with no clear return date. Now, this was not addressed to anyone specifically. 2 days later, the OSP declared Mr. Ofori-Atta a fugitive from justice, acting on an arrest warrant. So they obviously did not recognize this doctor's note. 6 days later, February 18, Mr. Ofori-Atta appealed to the OSP to remove his name from the wanted list and for the first time provided a definite return date, which was scheduled for May 2025, which was just 2 days before this June 2 we are in. Now, the OSP accepted his assurance and subsequently took his name off the list. So in February 18, we appear to have come to some compromise that Mr. Ofori-Atta will return May 2025. Now, but after that, in March, Mr. Ofori-Atta then files a lawsuit against the OSP and the special prosecutor seeking, so the man himself in the position, seeking compensation for what he called an unlawful declaration of him as wanted and asked for the removal of related publications from the OSP social media. End of March, the Human Rights Court had an interim application from Mr. Ofori-Atta asking that the OSP be barred from declaring him wanted again. Now, the OSP has been waiting for May to end to act. So according to a summary of the facts that OSP put out, they said they expected Mr. Ofori-Atta to return today, 2nd June, in person to the OSP headquarters. We heard from his lawyer, Frank Davis, Ken Ofori-Atta's lawyer, that he is unwell and cannot return anytime soon. The OSP has stated that if he failed to appear, his name will be added back to the list. So today, if we can hear a quick excerpt of the Kissie Jabing OSP speaking about the matter, he declared or redeclared Mr. Ofori-Atta wanted and issued an Interpol red notice. Let's hear him.
The Office of the Special Prosecutor first notified Ken Ofori-Atta of his investigations in January 2025, although he initially cited medical reasons for his absence and pledged to cooperate. The Special Prosecutor said the former minister repeatedly failed to meet deadlines to submit credible documentation regarding his health status. According to Mr. Jabin, after months of non-compliance, Ofori-Atta's legal team eventually agreed to a June 2 in-person meeting. But just 6 days prior, they informed the OSP that their client had been diagnosed with cancer and will require surgery, subsequently requesting a virtual interview. The OSP rejected the special prosecutor. Following his no-show on June 2, the OSP officially relisted Mr. Ofori-Atta.
The OSP redeclares that Mr. Ofori-Atta is a wanted person and a fugitive from justice. His name is hereby re-entered on the OSP's list of wanted persons. The OSP will take all necessary legal steps to secure Mr. Ofori-Atta's return to the jurisdiction and to answer to the criminal inquiries against him. In pursuance of this, about 30 minutes before this briefing, I triggered processes for the issuance of an Interpol red notice for the location and provisional arrest of Mr. Kenneth Nanaya Ofori-Atta in whichever jurisdiction pending extradition or his surrender.
Mr. Jabin also provided updates on other high-profile investigations.
So Mr. Kissie Jabing has re-entered or issued, for want of a better word, an Interpol red notice and declared Mr. Ofori-Atta wanted, which of course happened today. That timeline is the same timeline you have as well, right? So these are the facts as you know it. What do you make of where we are on this matter?
I think that I followed the interview that has been granted by Mr. Frank Davis,
yes,
who is Honorable Ken Ofori-Atta's lawyer.
Yes.
And he continues to insist that his client is still unwell.
Yes.
And is unable to respond positively to the invitation that has been extended to him by the OSP. Now, by and large, I think that there has to be some meeting of minds between the OSP and the lawyers of Honorable Ken Ofori-Atta, because they insist that the man is unable to come, to appear in person. Now, the law provides for other means of engaging him without necessarily having him appear before you physically. Under the Electronic Transaction Act, you can have a video recorded interview. Of course, there are instances where even an accused person or a witness in the course of a trial is unwell. The court can move to the locus to even take evidence of the person. In some instances, we call it preservation of evidence. The court can take evidence from somebody who is seen to be sick, and they are not too sure whether the person will be able to make it, and preserve the evidence for use at another date. under the Mutual Legal Assistance Act, Act 827, there is also room for Honorable Ken Ofori-Atta to do another, electronic engagement, and it is permitted by law. And I don't know where he is right now, but he must be in the United States.
Yes.
From what we realize, the United States is a member party to the Mutual, Legal Assistance Act. And if you check the schedule, you'll find that the United States is there. So it's easy for the OSP to engage. At the very least, Ken Ofori-Atta doesn't have to assist the OSP to prosecute him. He doesn't have any such obligation. In fact, every accused person has a right not to self-incriminate. So you can decide not to even cooperate with the OSP, but the OSP can still go on ahead with the case. Why is this lady who used to be a Maslock chief executive? I've forgotten her name. She was tried in absentia. All right? So you can go ahead, and go into the trial. But what is important for me is that there are options available for Ken Ofori-Atta to engage the OSP. So I think the OSP should take advantage of, this medium.
So do you think this declaration of him wanted and the red notice is then necessary?
In this era of digitalization, we should be able to see, some amount of, change. The OSP should take advantage of this digital platform, engage him. Let's see that, yes, he has... Look, in criminal prosecution, you must establish the guilt of the accused person beyond reasonable doubts. Give the accused person every opportunity, you understand, to vindicate his rights. You are not prosecuting because you want to convict. You are prosecuting because you want to put your case before the trial of facts, and then the court will make a determination. So it's as if Ken has been declared a criminal already even before the trial commences. So I think that the OSP may have all his cases, all his evidence and all of that right, but he should be able to agree to a suggestion that he should be able to engage Ken Ofori-Atta, wherever he is, via digital, platform, and see whatever evidence he's able to get from him.
Inusa, what are your thoughts on this saga?
First of all, Ken Ofori-Atta is not an accused person. He's a person of interest. He's a suspect. And that's why he's being asked to assist in investigations. The investigations is to grant him an opportunity to respond to certain matters that have come to the attention of the OSP. And a successful answer to those matters will exonerate him and let him walk away. If he fails to answer them successfully, he's then cautioned. And further investigations are carried out. And if those further investigations establish a prima facie, then he's charged for court. So this is the preliminary stage. 2, Ken Ofori-Atta is not an accused person. If he were an accused person, he would be entitled to a presumption of innocence. But he's a suspect. He's not entitled to a good name, because matters have come before the criminal investigative authorities, and they believe that he must assist in investigating them. So, and that is why a red notice has been issued. Has been issued because as a responsible and dutiful citizen of the country, he has a duty to assist in investigations. If he is charged, he can decide, he can elect not to write a statement or not to speak on the matter. But he is just assisting investigations. Now, and no one has said that so far Ken Ofori-Atta has committed any crime. But because he's a citizen who has a responsibility, a duty, to ensure that justice is done in these matters. And there's a likelihood of the commission of criminal activities in the 5 named areas which criminal activities touch and concern him. If he fails deliberately to appear before the investigative bodies to assist in the investigation, will be a fugitive from justice. So, and if he's a fugitive from justice, the only course of action open to the investigative authorities is to declare him as a wanted person.
I see, but if the OSP is so desperate for information from him, why doesn't he go to the US to talk to him? If the man says he can't come to Ghana because he's not well.
They are not asking for information from him. They are requesting him to assist in investigations. OSP already has a set of informations.
Okay.
And there are presumptions and hypotheses, which seems to be pointed in a certain direction. But that is what their preliminary investigations have revealed to them. Can he successfully respond to them? If he comes and he's unable to successfully...
No, there's a question. There's a question for you. He's asking a question. Ask the question.
Does he necessarily have to appear before them in person? No. The answer is no. He doesn't necessarily. He can even speak to them on phone. He can engage in video link with them.
So
if there's no law that says that he must appear in person, there's no law anywhere. So let's be very clear about this one. It is because that has been the norm over time. But in this era of digitalization, you can't use, the absence of a person as a basis to say the person is unreachable. When indeed there's a way that you can meet the person. Of course, what they can say is that they want to be able to engage him without and they should be able to see who is behind him. Probably giving him information to answer the questions and so on and so forth. Maybe you can say that, but that means that you can move to the locus. And your question is very, very important. They have every opportunity under the Mutual Legal Assistance Act to travel to the United States to engage him physically and then bring the evidence and then start your processes.
So, Idrissa, what's your response to that?
No. So, first of all, you just read Article 14. I don't think the words there were put there for fanciful reasons. A person arrested, restricted, or detained. So if Ken Ofori-Atta were in this country, or Wontumi arrested, now his movement has been restricted, in the sense that he's been granted bail on certain conditions. So that's the restriction. That's the police, the exercise of police powers. What you are talking about is not the exercise of police powers. When we talk about police powers, they are powers of compulsion, to prevent you from committing other crimes, to compel you to appear from them. That's why we have criminal summons. To compel you to appear. You are in the jurisdiction. But the criminal jurisdiction of Ghana is territorial in nature, except where it is backed by mutual, reciprocal arrangements.
And we have them. It's a Mutual Legal Assistance Act.
So, but the mutual legal assistance is different. What I'm talking about is simply that the whole world is united against terrorism. So if a person commits terrorism in Ghana and runs to another country, and that country is a signatory to a mutual legal assistance, that country has a duty to assist Ghana to get that person back to Ghana to stand trial. Or crimes against humanity. You know what? That is why in the United States of America, that crime or the crime of terrorism is of universal application or universal jurisdiction. So this is different.
I see.
Let me read something for you. Maybe it will give you.
We have 2 minutes, so let's make it
under the
snappy.
the Mutual Legal Assistance Act, Section 5 says that scope of requests: a request for mutual legal assistance in a criminal matter includes a request for assistance to identify and locate persons, to examine witnesses, to serve judicial documents, to execute searches, arrests, and seizures, to examine documents, objects, sites, for transfer of proceedings, for the prosecution, intercept communication. So there is a legal foundation for this proposition that I'm making. I mean, because the lawmaker is aware that we may have a situation.
No, he wants you to explain. It's legal foundation for what?
Legal foundation for what?
Legal foundation for engaging Honorable Ken Ofori-Atta in the electronic engagement that I'm talking about. Because the lawmaker is aware that there
he was reading.
He was
Where's
reading.
that foundation in the law that you just read?
Say that again.
He says, where's the foundation in the law
that you just read?
Oh, but you look at this. I'm talking. That's why I took you to the scope of requests. And we are talking about criminal. It makes specific reference to criminal proceedings. We're not even talking about civil matters.
I agree.
So you are tying the hands of the OSP, but the law has freed his hands so that he will be able to do his work without saying that I couldn't get the man.
Let me hear him briefly. Yes, go ahead.
What is the legal foundation for the electronic conferencing for mutual legal assistance? What is that foundation?
Let me read it for you. Mbe Inusa. In section 40, request for hearing by means of technology. And with the permission I read, if a person has to be heard as a witness or expert by the judicial authorities of a foreign state or a foreign entity, the central authority of that foreign state or the competent authority of that foreign entity may make a request for a hearing by video conference or any other means of technology designated by the minister.
And what's the name of this document?
This is Mutual Legal Assistance Act of 2010, Act 807. And no, it provides again evidence gathering by video conference. That's under Section 41. Section 42 provides that hearing of accused persons by video conference.
So you think the OSP has
there is sufficient
and this is a Ghana law?
These are Ghanaian
2010.
laws. You understand? So what Mbe Inusa is saying is tying the hands of the OSP. Now the law has expanded and strengthened his hands.
No, but let's think about what the OSP is doing, not what Inusa is saying. So is OSP tying his own hands?
So OSP is tying his own hands. He has every opportunity to move beyond, the office of the OSP, to go anywhere in the world, to enforce
Maybe he has to
the laws.
Explain to us why he prefers to have.
First of all, can I come in?
You have 30 seconds. We are wrapping up. So come in and we close.
So first of all, the first section he read was video conferencing of witnesses and experts.
And accused persons.
That's the first one.
An accused person.
The second one he read was for accused persons. Ken Ofori-Atta is neither a witness or an expert witness. And he is also not an accused person.
I think this is a matter of semantics.
So he's being investigated for now.
Semantics.
He's being investigated.
It's a matter of semantics.
It's not semantics.
So what is he? He's a person of interest.
An accused person is a person who has been charged with an offense, not so.
So he's a person of interest.
He's a person of interest.
So until the law explicitly states that a person of interest can go through this process.
How does he become an accused
All
person?
right, I think we can leave it here.
Yeah, he's not accused of any crime, has he?
Not yet.
Not yet.
Thank you, sir.
So what are you talking about?
We have to end it. Otherwise, I'll be accused of causing loss to my station. Alhaji Nusa, it's good to see you. Thank you for talking to us. We wish you well. Hope to see you soon in the flesh. And thank you so much. He is doing video conferencing.
That's exactly. You are taking full advantage of video conferencing
from his living room.
You don't want the OSP. Look at the very nice living room just that he's sitting on. This is my senior brother. Let Ken also have the benefit of the election.
As Antampoli's MP for Gushewu, Alhaji Nusa Hussaini is former MP for Tamale Central. Thanks for watching. For want of time, we'll have to end it here. We'll see you next time. Have a good evening. Bye-bye.